Without further ado, I want to welcome everybody. We are thrilled to have you here tonight with us. We're going to dive into an exciting topic on patents and intellectual property. So most likely you're sitting here today watching this webinar because you have an idea, an invention, or you know somebody that has an idea or an invention. So I'm excited to be joined by some industry experts here today that I will introduce shortly that are going to share critical insights into the intellectual property and patenting process. So whether you're just starting out with an idea or an invention, or you have already started the patenting process, we're hoping to deliver some valuable insights here tonight to you guys. So before I jump in, I'm Bailey Roshala. I'm the operations manager at Ideal Strategic Partner or at Idea Path Academy. And tonight's webinar is brought to you by Ideal Strategic Partners in sponsorship with Idea Path Academy. And so we also want to acknowledge tonight that, each of you is coming to us with your individual circumstances, and tonight's information is really for educational purposes only. So keep that in mind. And lastly, I also want to give a big thank you to all of our registrants that took the time to submit questions ahead of time. We thank you for your participation. We're very excited to have curated this content to address a lot of those questions. And if you still have questions throughout tonight's session, we encourage you to email info@ideapathacademy.com. I'm going to have my producer behind the scenes drop the email address right there. So I'll be keeping eyes for the next 30 minutes on that inbox. So if anything comes up and you want to ask a question, just know that at the end of tonight's session, we're going to wrap it up with a live Q&A with these two gentlemen here. So I'm excited to go ahead and introduce our speakers that we have here tonight. So first off, we have Scott Moffitt. Scott Moffitt, he's our co-founder of Idea Path Academy and also our head of partnerships at Ideal Strategic Partners. And, Scott has dedicated his entire career to guiding innovators from concept to market launch. And so it's really through his experience in this space that he has developed a passion to empower entrepreneurs with the knowledge to navigate these types of processes when launching their inventions. And so next we have our special guest here tonight that we are pleased to introduce to you guys. We have Kevin Bronson, and Kevin Bronson is a registered patent attorney with Simpson & Simpson, and he brings a wealth of knowledge to tonight's discussion. And it's through his experience with intellectual property strategy, patent writing, and a unique background in robotics and CAD design that he's going to provide a lot of insight to each of you guys tonight that you can hopefully carry on to take the next steps with your patent or your invention. So now I want to kick it off tonight by asking Kevin, like many of our viewers here tonight, they have a product idea or they have an invention and people tell them they need a patent. I'm going to throw this out to both you guys now. So what are their next steps?
Well, you want me to start, Scott, or you want to get the ball rolling?
You're the patent attorney, so I feel like it would only be appropriate for you to start.
Perfect. All right, let's just start off with the basics. Let's keep it really simple. I know there's probably many people here. You may have already started the patent process, and you may have a product already, or you built a prototype, and that's great. What you have right there is an invention, and you're probably patent pending. But just so everybody knows, there's a distinction, right? An idea, something you think about. Maybe you're just chatting with your buddies, like Scott, you and I, we're hanging out and we think of something awesome to solve a problem we see. That's just an idea, and you can't patent ideas. It needs to be an invention. And when I say invention, I mean something that you've taken out of your head and you've put thought to it, right? You may have built a prototype. You may have built a couple prototypes. You may have CAD drawings. You might have models, specifications, materials, parts list. It's not just what you sketched out on that napkin paper if you're hanging out at the bar with your buddies. It's more than that. So first and foremost, if you want to go get a patent because you think you have something that's worth protecting, it's got to be an invention. It's not just your idea. And I'm sure you can kind of jump in here with what that entails.
Yeah, that's a great summary from a legal perspective, and from a business perspective. The only thing that I say I feel a little bit differently is making sure that it's not patenting something that you think is worth protecting, but something that's been validated to be worth protecting. So, part of a lot of what we do in our business is coaching people on patenting and the patent process, that being a resource, right? Unfortunately, a lot of people believe that getting a patent is a destination. The patent is a resource. It's a tool in the tool belt. It serves a lot of different purposes, which you can go in deep into detail about. But understanding exactly what you're building and making sure that you're not building it for yourself, but more so for the addressable market before entering into that patenting process is important. But so a lot of people will ask, Kevin, I did this because I like this idea, right? And I want to pursue it. But before I really throw money into it or pursue it, heavily, I want to get some feedback from people. So I want to talk to people about this, right? And we've all heard, or at least I'm sure a lot of us have heard the saying, "Loose lips sink ships." And they also do. They also do more than that. They if not done correctly, they start a clock, which I think would be a good segue. Maybe you could talk first, Kevin, just about the three things that constitute an invention, right? And then also maybe lead into that by going into maybe when is the right time or how to have those conversations without starting the clock, which I'm sure you'll explain as well.
So in invention, we'll just start there and we'll make it really simple. Basically, when you are trying to patent an invention, so you're applying for patent protection, that's a protection that's afforded by the US government. All right. There's three things that you have to have. The first is it has to be useful and it has to be in a category of inventions. So you can't have something that says, I only have to put in this amount of energy and it puts out more than you put in. That doesn't work. It can't be a perpetual motion machine. It can't break the laws of physics, right? So that's not useful and that's not an invention. All right. So it's got to be useful. And most times if you're thinking of something like an actual product, it usually does something. You have a specific reason for it. So that's the first step. It's got to be useful. Second is it's got to be novel. And what I'm going to do to kind of set the stage for it is, in the eyes of the law, you're an inventor from the minute you file a patent application. Okay. It's a first to file, not first to invent. So even though you may have invented this in your garage, in your basement, and you worked on it for years, the law doesn't recognize that activity if it's just to yourself. It recognizes the date that you actually file a type of patent application with the USPTO. And from that date is where you measure, are you novel? That's the second step right there. So it's novelty. Are you at least a little bit different than everything that came before that date you filed? It's not a super high bar to pass, but at the same time, you can't be exactly the same, right? You have to have something that distinguishes you from things that came before you. Lastly, is you have to be non-obvious, and we could have a whole discussion about it, but I'm going to try to make it very simple. You have a category that your invention or product falls into, right? It could be like a hand tool. So we're thinking about tools, right? The law is going to ask, would somebody who has skill in the art of hand tools, not an expert, not somebody who's never swung a hammer, right? Just like regular, ordinary skill. Could that person look at everything that came before you filed your application and combine them or find a suggestion or a motivation to come up with what you have, right? If
Does
they
it pass the
can,
common sense test, basically?
yeah, I think common sense is a good way. There's a lot more to it, but that's a good way to put it. It's a common sense test. Could they look at two things and come up with your invention? If they can, it's obvious and you're not entitled to patent protection. But if they can't, because they didn't think of the problem you're solving, or they didn't know how to make it a certain way, or the structure is simpler, it could be a lot of different things, then it's non-obvious and you're entitled to a patent. So usefulness, novelty, and non-obvious. And then to wrap it all up, what are you going to do if you start telling people loose lips sink ships? Well, first off, you don't want to do that. When you publicly disclose, you set a timer and you only have 1 year from the date that you do that. So if you tell somebody down the street, maybe someone wants to invest in your company, you tell them, or you offer it for sale. You basically say this is going to be available on this date and I'm taking pre-sale orders. You've offered it for sale, or you sell it. Those are all public disclosure events. And that means you only have 1 year from that date you first do any of those events to file for patent protection, or else you're considered barred. which means you won't be able to. So you give it up to the public domain. So for
Okay.
everybody watching, keep it tight.
So Kevin, though, and I mean, let's say someone, and I'm sure there's quite a few people watching this will fit this description. They've developed this product, or at least a prototype, right? And they've had some people look at and test it. Maybe they're friends or family members, but maybe not. Maybe they haven't shown it to anyone yet. They've been in their basement. But before they end up going for a patent, so they check all three of the boxes that you said. From a business perspective, that's where I'm going to say I still don't necessarily think that is the right time to patent. There's certain things that I believe go into that. Those are the qualifiers to be able to do so. From a business perspective, making sure that you know what you're patenting is very important, and part of that is understanding what people are going to be interested in. So then the question begs itself: how do I figure out if people are going to like my invention or want to use my invention if I can't talk to them about it without starting this clock?
Well, I, obviously this is my profession, so I'm going to say that patent pending is the best way to go about it. Once you file, you basically have marked your date of what your invention is in the patent office, but that's not always practical, and I get that. That's just at the end of the day, there's a whole business aspect. You have a reason that you're trying to protect your invention or your product, whatever it might be. And so if that is not really, you're not ready for that, whether it's finances or maybe this is only, the first version, or it's still a rough prototype, you don't know if you can manufacture it. There's a lot of reasons why you might not really be ready. At that point, you want to have an NDA, a confidentiality agreement, and you want to have any individual who you want to introduce this idea or product to sign that, because at that point, that's not a public disclosure. That's done in confidence, and then you're able to kind of work on these aspects you're talking about. Manufacturing is a big one. I know you and I have
Yeah.
worked together and talked about things. Well, if you need to figure out, I got these prototypes, but I can't build them all. I got to find a manufacturer. Well, you've got to put that manufacturer under an NDA. They have to sign it, because that might highlight things that might change in your invention. And at that point, maybe filing a patent application could be premature anyway. And so you want to try to balance these things. And it's hard to sum it all up with the limited time we have. But if you can't, go to the patent office or get an attorney to help you with it, an NDA is a really, really good start, and it prevents that clock from starting.
And I also want to encourage the viewers as well. I know that this is something that I've come across. A lot of people have shared with me is sometimes they just feel, well, it's my brother or it's a family member, and they feel a little bit apprehensive, almost as if it's somewhat of a prenup, like they don't trust them. And I just want to encourage even friends, family members, and it's not that you can't trust those people. It's number one, what Kevin just mentioned about starting the clock, but number two, when you come with that level of professionalism to conversations, you're going to be viewed differently as an entrepreneur. You're going to have your ducks in a row. It's going to be clear that you know what you're doing, that you've done your due diligence. So I would just encourage anyone who might be hesitant about the NDA side of it, do it, because I believe from a business side, you say patent pending, and we could talk about how that starts another clock, right? And we'll talk about that in the different types of patents. But there's something you said recently in one of our conversations. 5% of patents actually become products. And that in a way blew my mind, but in another way didn't blow my mind, because so many people, there's this, you have an idea, I need to just hold it to myself or go get a patent. And that's just not the right solution all the time. Sometimes maybe, but I'm more of an NDA and delay guy. So
yeah, NDA and delay. I think in a lot of, at least how you and I have interacted, and I would say a decent amount of my clients that I work with now, sometimes that is the best thing to do, because I might be helping you to prepare and file a patent application, and it might not be right for it. You might still have developments, there might be changes down the road. And it might not be the most appropriate time. So the next best option is obviously an NDA, and there's an economical piece too. So I think that's really important. Also, I think it's a really good point. If you're serious about, obtaining your own IP, intellectual property, you want to build a patent portfolio, you want to protect your invention. Yeah, I'm sorry, it might be your brother, but you got to take it seriously. And you may not have engaged with a manufacturer yet. You might not have a partner, you might not have an investor yet, but if you're going to try to grow a business behind this product or invention that you hopefully patent one day, then you need to start practicing, the seriousness of it. because
Absolutely.
I want to know that, okay, 18 months ago I told so and so, maybe it was your cousin, but he signed an NDA. Great, perfect. I don't even have to worry about it. But if you told me 18 months ago you told your cousin or something, and I mean that's tough because now it's, well, you kind of did publicly disclose it. What was the relationship that didn't make that a public disclosure, right?
Right.
So that's a good practice, and I think everybody should really start implementing it. And it makes my job, makes your job, and it makes other people that you're trying to interface with take you seriously. It's
Oh
important.
yeah, absolutely, and that's part of, and you have to look the part and act the part, and that's when it comes to being an entrepreneur, covering your butt is important, and making sure that you do so legally is obviously important. So I think that's a good segue. Let's talk about, okay, you're ready to patent, right, and or you're ready to start the patenting process.
I'm
Obviously,
there.
obviously the first thing is the A or the attorney, right? Everyone's you gets intimidated when they hear the word attorney. You're not very intimidating, although you are 6'4", but you are not very intimidating. I think that first of all, before we talk about interviewing attorneys or what people should look for, or red flags versus areas you might want to pursue further, let's dig into, all right, someone's got an invention, it's novel, they feel comfortable and confident, the different types of patents. Maybe you can outline those, and maybe just high level the value on each of those as well.
Okay, let's divide it in two groups because I think that's the easiest way to do it. There's actually three types of patents. The third is a plant patent. If anybody here is, for some reason, did something related to that, you can talk to me later. But let's go to the most common two. You have utilities and designs. I'm going to start with the design patent because it tends to be simpler. And the reason why I say that is because it is protecting how something looks, right? It might not be like a new object, it might not be a new product or anything, but you have a certain design to it. It looks different, it sort of carries your brand, you know. That's an ornamental appearance, and that's what a design patent actually protects, is what it looks like. So with that being said, there's no function, right? So you're not really going through this whole analysis of what are the components, what do they do. So necessarily it doesn't cost as much, and you can get it faster. Okay. It lasts 15 years from the day you get it, and you can prevent others from make, using, selling, offering for sale if it's substantially identical. We could go into why I'm using the word substantially, but just know it really needs to look the same. Okay.
What I've heard in the past, Kevin, tell me if this is correct when it comes to a design patent. If the design, whether it's shape, size, if it can be even modified by 1%, then it can be circumvented. So it's got to be something, whether it's that exact design, or if you change it, it doesn't have the same result in the utility it's being used in, and the process being used in. Is that accurate, or would you
It's
go a little
actually not, but
Okay, correct. I
that's
love
one
being
of
corrected
those
by you. So
that's one of
please.
those good that's one of those good things where, sometimes you can get a bad idea about attorneys because I can't tell you, exactly something's black or something's white. It's
Right.
somewhere in the gray.
It depends, right?
It does. And the reason why is it depends on what's in that field.
Right.
And you know how we talked about the first day you file, you're measured on everything that came before it. Well, that's kind of the inquiry of whether or not, your design protects something that's close, right?
Right.
Is the field that came before you, are they all way different? Or are they really similar to what you did?
Right.
So if everything came before you is super similar, so the differences are tiny, your protection is going to be more narrow. But if everything came before you is super different, like you really don't look like the other design patents that were filed, or the prior art, as we call it, you're going to have kind of a broader leeway.
Right.
There can be some changes in the design. I'm not talking monumental
Right.
things. So it does. It depends because it is what the field is, right?
Understood. So how does the design, then there's the utilities. So let's talk about
Yeah, the
utilities.
utilities is really that's where a lot of the patent discussion is really based on. And we're just going to kind of divide it in two steps. So you have a provisional patent application, and then you have a non-provisional patent application. And just so everybody watching, and Scott, we talk about this all the time, you want to show up talking to your investor, your manufacturer, potentially you're going to try to strike a deal with somebody to sell some of these things, right? You want to talk in an educated manner. If you filed a patent application, you're patent pending as of the day you filed.
Mhm.
You aren't patented, right? You're not patented. And I know that sounds silly, but to somebody that potentially is going to be your investor, right? Or somebody who's going to manufacture, there's a big difference between I'm intending and I'm working on getting a patent versus I have a patent.
That's
If
like
you have
lottery.
a
That's like
patent,
lottery pending. I bought a lottery ticket, so I'm pending to win. Right?
yeah,
There's
you didn't
no
win
guarantee
anything
that
yet,
you're ever going
man.
to have a patent.
Yeah, exactly. You want to speak educatedly on that, and you want to make sure that you're using the right terminology. Patent pending, yes, I intend to get a patent, and nobody quite knows yet what I'm intending to patent.
Can I talk about that for 1 second? Because I
Yeah,
think that's
yeah, go ahead,
important.
man.
And one of the big values to patent pending from a business perspective is the analogy I use a lot is, if you're playing poker and you're at the poker table, right, and you're holding your cards in your hand, nobody else can see them. Well, they don't know how to play their hand unless you are really bad at poker and you give a lot of tells, and they don't know how to play their hand. Now, once your cards are face up on the table and everyone at the table can see your cards, they know how to play their hand much more effectively. And so the value to patent pending from a business side of it perspective is that, just as you mentioned, nobody can see the contents of what you filed. So if you launch a product, you're in the patent process, it's patent pending, it has not been made public, it's not on the USPTO, it's not on Google Patents. So a lot of the bigger names that you might be intimidated will come in and step on your throat, and because they have deep pockets and big brand recognition, they may be a little bit more hesitant, because if they step on a landmine, it's going to be very, very expensive for them. So it's almost that patent pending gives a runway to be able to build out some of that brand equity and get some traction, some sell through. That's from a business perspective how we view it. So now, from a legal perspective, I'd like to hear how you view that
Well,
patent.
we can go right back to the kinds of patents for utilities.
Right,
Provisional comes first. It
right,
never becomes a patent. And the minute you file that, you're patent pending. Provisional patent applications are always confidential. So exactly like you said, you know, nobody's going to be able to know the contents of what you're intending to protect, right? So that's really good. That allows you to kind of finish off the manufacturing process. In your circumstance, it helps you build the brand. You're selling a patent pending product, and nobody really knows what part of it you're intending to protect. Um, that can continue on, because a provisional patent application, it only lasts a year. At some point before that year, you have to convert it to what I call, everyone calls the non-provisional patent application. This is the real deal. This is the one that gets examined. This is the one that, the United States Patent and Trademark Office is looking. Are you useful? Are you novel? Are you non-obvious? And they're not looking at the entirety of it. They're looking at something called the claims. So, Scott, we talk about this all the time. What the heck are the claims? Anybody, if you pull any type of patent up on Google Patents and you go to the very last page, there's going to be a bunch of numbers. Those are the claims. And basically, that's the equivalent of your property description in your deed. It could be a survey. It could talk about, maybe you have one of those double driveways you share with your neighbor. It explains what you own in that deed. The claims explain what you own in that patent, right? And that's everything that goes into that non-provisional application. And when you file that, so let's say you file a provisional, 1 year goes by, you convert it to the real thing, you still have another 18 months before it publishes. All patent applications eventually publish when they are non-provisional. So utility, you've done your provisional, you're doing the real thing, you're trying to get a patent, 18 months after, then it publishes. So you see what you submitted, and everybody sees that. So that sort of patent pending grace period of confidentiality, it does eventually end.
that's good.
There is one exception. We talked about that before. If you only want to protect in the United States, you can opt out of publication. So
PCs.
nobody can see it unless you actually get the patent. You can do that. But if you choose to do that, you give up your foreign filing rights.
Which is a
what I mean by that,
PCT, a PCT.
yeah, you can do an international application. I'm in Buffalo, so you could do like a Canadian one. You could be down by you. You could do one in Mexico or somewhere else in South America, Europe, China. It depends, but you have to allow it to publish if you want to do it. We're going into kind of the weeds there, but provisional, non-provisional, utility. Generally, it's the structure. It's what it does. It's the actual thing. It doesn't matter what it looks like. You're looking for certain aspects. What parts? What's the function? You're actually kind of building the product, not just what it looks like.
Makes total sense. I have one quick bonus question for you because this goes
Oh
back to
boy.
the business. This goes back to the business side of it, right? I mean, I have a tremendous amount of respect for you and what you do and your level of expertise. You know, in certain things from business perspective is just viewed a little differently from a different perspective, I
Oh
guess is
yeah.
what it is. So, you know, one of the benefits to holding off on that process is when you mentioned the 12 months, you know, I think we should emphasize you only have 12 months to convert that into utility. So once you
Yes.
file that provisional, you only have 12 months. Now, if you go straight to a non-provisional, a utility, now this is something that's important too, because it'll be pending for at least 12, maybe 18 months, maybe even longer, depending as it goes through
Hmm.
process. But you can't add new matter at that time. Now you can do,
Yeah. Yes. Yes.
so that's why, and this is what, you know, I've learned quite a bit from you, but that's why, but delaying and NDAing and having these conversations, you know, you can go out and think, oh, I'm patent pending. I can start telling everyone about this. And yes, you can. But in doing so, you might learn that there's some critical errors you made in developing the
Or
product that your
there's something
market's
with
not
the
going to like.
market that you need to incorporate, right?
Exactly. Exactly.
That's one of the things we talk about, especially when you're we're working together. We found out that this group of customers, maybe it's 25% of these customers, they want this aspect. We can put it in there. We already have an application filed. Sorry, guys, we
New
have to
matter.
file a new one because, like you said, it's called new matter. And so once you file, you can't change it. Now, let's break that down a little bit. You can change it within the bounds of what you set. So if you change names or you change numbers, you know, and it's not adding something completely new, you can do that. But if I have component whatever A, B, C, that's what makes it up. And I have a bunch of customers that are like, oh, if we had D, we would buy all of this for the team. Kevin, can we go add D? Sorry, we have to start over.
Yeah.
That's one of the reasons why earlier I was saying maybe it's not ripe yet. Maybe you
Right.
need to, you know, talk to other people. Maybe you need to think through some of the problems it's trying to solve. And that's another thing on my job is I'm constantly asking,
Right.
what is this going to have in the future? You know, is there any other things that you think you might add? Because I'm trying to see, like, is there some other stuff I got to try to put in here before we hit the file button and this thing's
Well,
in?
it happens all the time, right? I mean, I've been at trade shows with our portfolio partners, and we'll have vendors that'll come up and, you know, they'll ask, can we make that product in our brand shape? I remember I called you from one of the trade shows I was at in New
I
York a
remember
couple of
that.
years
Yeah.
ago, and we added into the application as it was getting filed. So my point in saying all that is that a process that can already be pretty expensive in patenting can become a lot more expensive if it's mismanaged. So if there's new matter that you don't include, that means you basically are filing another patent and you're layering those. And we could talk for a long time about that. So
Yeah. Yeah.
instead of doing that, let's talk about, okay, so someone's ready to take that step. They feel like they've checked all the boxes. And for those of you, by the way, you have a patent, we are still going to address some of the things. I know we talked about mentioning that as well. But for those who are saying, okay, I'm ready to do this, I'm ready to engage with a patent attorney, you know, what do I look for? What questions do I ask? I mean, what's the lay of the land coming from an insider?
Where do we want to begin? Are we going to try to pick who's going to do the work? Do you want me to do it? You want to talk about
Well,
who to avoid?
I think, well, I mean, look, if you're, let's just say, you know, you're, you know, John Smith and you're in Dallas, Texas, and you're looking for a patent, you're looking to get patent work done. You know, you might start on Google. If you don't have any personal referrals, you're looking at companies. What are you generally looking at in terms of company structure, you know, specialization, team?
Yeah. No. Okay. So let me try to break this down. You just came up with a product, right? You're new to the game. Maybe you have an investor. Maybe you have some plans to make it, and you've kind of identified a market base. So you've kind of done the homework stuff that we've talked about. You probably have invested money into manufacturing. Maybe have done R&D. You maybe invested into marketing. So you need to be, you know, very well aware of what you're spending. My advice is the same that I kind of tell everybody. First and foremost, you know, you're not going to your primary care physician to get your foot checked out. you're going to a foot specialist. So let's get that out of the way right there. It's kind of obvious. We all call ourselves patent attorneys. You should be able to identify who can do it. And also, we have to take a special bar. Not just any attorney can practice in front of the United States Patent and Trademark Office. So there's prong one. But in that circumstance, entrepreneur area, you really want to find somebody who is locked in on the patenting process. They don't have another agenda, meaning they don't probably have somebody down the hallway that's going to be able to handle all your business stuff. They're not going to be able to deal with your employment things. They can take care of your IP, right? But you want somebody that's totally focused on that. And there's a couple reasons for it, especially early in the game. Okay. The costs are probably more reasonable because you're not dealing with huge overhead. Now, you've sold an absolute crap ton of these. You have grown your company more than you can handle, and you've got to deal with all the corporate stuff.
Work with them.
The, the boutique firm or the specialty or the solo practitioner might not be your best choice because you have got more than one legal problem, maybe not problems, but you have more legal questions that need to be resolved. It's probably better in that case because you're already making money to go to a firm where you have multiple practices that can take care of your whole outfit. But that's not usually the case with everybody, okay? You're just starting out. You need to go to the people that are focusing on these parts. And it might sound like it's a lot of work, but you want somebody who's just going to look at your invention, at your product, and that is their sole job, is to write you the best patent application possible. And that's all they're looking at. They don't have another agenda to try to move this somewhere else. And that might not be the case for everybody. You know
It's
what I mean?
it's their specialization, right? If it's like when I go to a restaurant, if I see a
Well, you're going to find that
four-page
anywhere.
menu,
I have to be real about that. If
right,
you go to a big firm, a lot of them are going to have an IP department. But at the
right.
same time, you have to weigh when it's appropriate to be at one or the other. There's a reason why a lot of huge companies are with huge law firms. It's because they take care of multiple aspects and it's under one roof.
Everything
That
under
is
one roof.
convenience. You pay for convenience. That's the reality. Many of you might become really successful in the future, and that might be a really good option for you. Some of you might be, whipping products out left and right, and you need to make sure the IP is really good because maybe you're worried about infringers. The big firm's probably going to do a good job too. I'm not saying they're any worse or better, but it might be more advantageous for you to have somebody that's locked in just to that. You have to take an examination of what you have as a product, what you have as an entrepreneur, and what you have as a business owner to make those decisions. And my recommendation early in the game is find somebody that's just going to be locked in on that. It's not to say that you're there forever, and it's not to say you can't switch to somebody else. That's how it goes. You can switch, but that's probably my best advice. I would avoid the $200 provisional ad that you see on Google. I would definitely avoid that if you can. I know that, you're investing in all these things in your product, but that's usually a bit of a red flag. And unfortunately, I do have a lot of stories of clients that come through our doors because they fall through that trap.
Yeah.
And I don't want anyone to fall victim to that, but it's very appealing because it comes right at you. They do the sponsored ads and it can cause more headache and it might cost way more in the end. You might pay $200 now or whatever it might, but it's not going to get you that high quality legal work that you need to ultimately get yourself a patent.
Well, mistakes cost you time and money, right? So if it's there's a happy medium where there's obviously what people are able to afford, right? And then you're not going to go to McDonald's for a steak, right? And so at the end of the day, when you're looking at having something done, and you want to have someone who has an area of specialization, right? So I mentioned this before, but if I go to a restaurant and they have 4 pages of different menu items, nothing to me is probably going to be great. If I go to a restaurant and they have 4 things on their menu, there's a good chance every one of those 4 things is going to be great. So having that area of specialization, I also compare it somewhat to banks. The big banks, not always, but in a lot of situations, you're more of a number, right? With credit unions, there's more relationship driven, getting to know you and your needs and what you're working toward. Again, there's outliers to all those scenarios, but I do, I've worked with the big patent firms. I've worked with the individual people who work out of their home, and I've worked with the boutique firms. And in my experience, that's very sound advice. Now, when you're sitting down with a patent attorney and you get a meeting, you pick a firm, what are, let's say, the top 3 questions that you would ask them?
Well, besides cost, because that's going to vary all over the place depending on what type of invention you have, how far along you are in the process. Are you in a big city, a little city? Are you a solo practitioner, boutique firm, a big, that's just such a variable thing. I tell everybody that it can vary from buying just a regular used car, nothing special, to getting a really nice brand new car. It really depends on what you're trying to protect. Okay. But one of the things that you kind of want to ask and you want to kind of see is the patent attorney doing their number one job? And our number one job before we do anything else is to understand the invention. So that's the first thing. I don't even know if that's a question, but that's an observation.
Right.
And if you feel that, okay, describe it back to me. They're talking to you. So I would talk to you, Scott, about what I'm seeing, and I'm going to start putting words to it. I'm going to name things. I'm kind of practicing. Okay, well, how are we going to write this? How are we going to draw this?
Right.
You want to kind of have that dialogue and understand that that patent attorney understands your invention, because I can't do anything else. I can't argue it's novel or it's not obvious if I don't understand the invention. That is going to always be the chief ask, and that's through observation and ask questions, constantly ask questions. And those questions are all related around your product. Do you understand it does this? It can do this. Do you think that we could make it with screws instead of nails? That's the type of things that should be on your mind to begin with. Also, you should be seeing if your patent attorney is asking you, have you publicly disclosed this? That should be a good question. They want to know, because they shouldn't be filing your patent application if you publicly disclose it. And they should be asking you. And if you haven't heard that question, or you're wondering, oh, what's that mean? Well, you got to learn, we're trying to educate people here about it so that you can come more prepared. But that's one of the things, you want to hear them prompt. It should be the patent attorney trying to ask you a ton of questions. And 90% of those questions need to be completely focused on your invention, product, prototype, whatever you bring. The other 10%, maybe some goals. Maybe you're talking about costs. Maybe you're talking about a relationship with somebody who might have a financial interest in the company that is being formed around it. That's like the other 10%. It really should be focused on, what you're here to try to patent.
That's good. That's good. So I know we're going to come up to the Q&A time here shortly. So
Awesome.
before we do, I'm sure there's also a decent amount of watchers, listeners who they have either a patent pending, a non-provisional utility patent pending. They might have been granted a patent. And a common question I get asked all the time, it's less of a question, more so that they want to license their patent, and that they think that's, so we're going to do a whole nother, there were so many questions that came in specific on licensing, and we could talk for an entire session on that.
Are
So
you bringing me back? Is this the official invite?
we're going to bring you back. We're going to bring you back.
Nice.
We're going to talk about licensing, and that's, we're going to have an episode on that. But for someone who says, okay, wow, I really maybe rushed into getting a patent, right? I wish I hadn't, but I did. I'm already learning things that I might want to tweak or add. And, and I really, this idea is my everything, right? I really want to pursue it. Am I dead in the water? What else can I do? For someone who's in that scenario, some might have worked with an invention promotion company, which, Google that and you'll figure out everything you need to know and about that. But, or some might have a really strong patent, but a patent alone, and this is why it's a resource, it's a tool, it's not a business, because all the time people they get granted a patent and they celebrate and they go out to a nice dinner and they wake up the next morning. Now what? Right. And so for those people who, are either patent pending or have a patent, and maybe they know they need to add to it, or, maybe they didn't include everything or go the right process. What would you tell people like that from a legal perspective?
It's not the end of the world. So let's just start there. It's not the end of the world. The patent system is built such that you can build what we call a patent family. And that means that, yes, you do have to file another patent. Because remember, we talked about new matter, but they can be connected. And we call that priority. And when you have a couple of them, it's called a patent family. It's a very common strategy for very big companies because they're constantly developing. The only thing that you have to do to make sure that that can happen is you have to have a patent application pending. Okay. So it hasn't been granted yet. It's not abandoned, meaning you didn't let it go. It didn't expire. So maybe you had a provisional and you let it go longer than a year. It has to be pending. And also, let's say you already got the patent. We're going to focus on what the new aspect is. All right. You can just file based on the new aspect. You're protecting the new aspect in combination of what's already there. You're not doing the baseline, the first thing, you're looking at the new stuff.
So you're
So
referencing, you're just going to reference the older
yeah, you
patent.
could reference it to build, but then you're talking about this new aspect because, like I used that example before, I got a bunch of my customers and they want to solve this problem, and I can use my device, but I need to modify it. It has to be able to do this. Great. You have a new problem to be solved. That's a great argument to the patent office of why you're non-obvious.
Right.
This problem wasn't there before, right? And I figured out a way to solve it. So that's a really good way to go. You're just looking at this improvement, but you're solving a new problem. Maybe your application's still pending. Well, you could file what's called a continuation in part. It means you have everything from your first application in part, something new. Like we said, could be a new problem, right? So you could do that as well. And maybe it's a provisional application that you let expire. And maybe you really haven't told anybody yet. Well, it's great. That provisional application never publishes. You never publicly disclose. You could file the exact same thing as you started in another provisional and you could add on to it because it never got exposed to the public. All right. So that's where, we're trying to put all these things together. I guess we're going to go back to the beginning there. Delay an NDA if you aren't ready to
Right.
put something together. Talk to your people, but do so where you're not going to give yourself these timelines. You're not dead in the water, but you may have to, reinvest and try to examine, okay, what do we have to do and what do we have to add? We might have to file another patent application.
And be able to take a couple steps backwards to take bigger steps forward. That makes
Yeah.
total sense. I think one of the big principles that that I've learned a lot over my career and it's really helped me is, a lot of this information is going to be valuable to our audience. And there are people who reach out to us and I'm so impressed with them. They had an idea and they were so passionate about it that they dove in and they actually wrote their own patent and they took the time to do it. Now, I don't advise that because it's like, your average regular person going and doing surgery. I mean, it's a very specialized art. I don't advise doing that, but I do appreciate the initiative in doing so. I think just to summarize, it's important when you're becoming an entrepreneur, when you're inventing a product, when you're doing anything, it's important to surround yourself with people who are elite and know a lot more than you. A lot of people, they take the initiative and they go out and they try to learn this stuff themselves. And just from an entrepreneur's perspective, you don't have to know everything about everything. You have to know somebody who knows everything about something and the top 1% in each of those functional areas. So when you talked about, interviewing patent attorneys and asking questions, relationally, experience, I mean, making sure that they really know what they can do and talk about what they've done with other, with other projects and what they've been a part of. So I would just, the relationship side of it, working with people that you can trust, that you really connect with. I think that's very important, but don't try to do it all yourself. As an entrepreneur, there's a million different hats to be worn and you'll already have to wear a lot early on. Trying to go through law school on your own with no legal background is not an area where I recommend trying to cut a corner. And I think, Kevin, you probably agree with me on that. Some areas you can get away with it. Legal, I wouldn't cut that corner.
I mean, I went to law school and I'm barred in state and I'm also barred in the United States Patent and Trademark Office. If I get a speeding
Is that
ticket,
really the terminology when you say you're barred? I mean, does that mean because usually
yeah,
that
I
would mean
guess.
like
So,
you're
I don't
not
really-
allowed?
I don't really think about it. You take that test and you hit that pass, you don't want to go back. But
Yeah.
my way I do it is if I get a speeding ticket, I'm not handling it myself if it's that bad.
Right.
And I'm an attorney. I'm not going to. I'm going to call another attorney as the expertise. So use your resources and find the people
Show up
who
in
are
court.
experts.
This is not novel.
Yeah, I wish it worked.
They won't throw it out.
It
So
doesn't quite work that way, but
yes.
more typing. Hi, Bailey.
I'm back, guys. Yeah, and I hate to even interrupt because I know you guys could go on for hours on this topic, and it's really been such a lively discussion so far. I love hearing from you guys. I know there's so much insight and passion behind what you guys do, but we are here around the 45-minute mark, so I definitely want to get into the Q&A because this is always probably my favorite part of the session. And I know, we had probably, I think, almost close to 100 question submissions. So we tried our best to really touch on as many of those topics that we've even discussed up until this point. But looking at all those questions, we were able to see some patterns and some themes. So I really want to touch on some of these that we saw come in and that, consistently
Let's do it.
questions. So
Kevin's going to stay
ready?
on Kevin's going to stay on for another 2 hours and make sure we go through all 100. I might have to leave, but let's kick it off.
Oh, goodness. Okay. Well, I think you guys talked about it just a few moments ago, but this was one that I saw several times. And so I've kind of re-summarized it to try and touch on everybody that asked this question. But okay, I've worked with an invention promotion company in the past, specifically we've seen names like Davidson and Invent Help, and they didn't feel like they got what they were promised. So these people are either in process or have already gotten a patent through these methods. And so they're wondering, what do they do now? So what kind of insights can you provide to these people?
I'll take the first stab, but then the legal side of it, I'm going to defer to the legal specialist. Invention promotion companies, and you named a couple of them. There's probably about 8 or 9 that are pretty well known, and that's the classification. So I'm not here to throw stones or talk negatively about anyone. I would just encourage everyone who's watching this to do your homework. Do your homework. If you had enough wherewithal technologically to join this webinar, then you can find out everything you need to know about invention promotion companies and what they do and what they don't do. The long and short of it is that a lot of their processes revolve around an initial conversation, $800 to $1,000 comes in the door for a marketability search, which they actually don't even perform. And then it's just a constant, you have a great idea, send us money, send us money, send us money. And ultimately they farm it out to, a law firm that does more of an assembly line type process. And I know Kevin can speak more to that legal side of it, but their whole model and what the vision, and I hate to lump them all in, but when you've been doing this, just almost to be 20 years, there's too many similarities not to do so, is basically, the explanation that you've got a great idea, get a patent, and these billion-dollar companies are going to bang your door down ready to send you mailbox money. If it was that easy, I wouldn't be on this webinar. I promise. It's not. So there's a lot more that goes into it. And I feel like when people realize that, they feel misled and they no longer trust that relationship. And I don't blame them. I would feel the exact same way. So from a business perspective, I will tell you, a lot of our partners have had interactions and have even worked with them. And some of them have even gotten patents through them. I will say they were not quality patents, and there's needed to be a lot of reworking done there. But there's a process. Licensing is where everyone wants to go. That's why we're going to have a whole segment and talking about licensing coming up. It's where everyone wants to go. It's mailbox money once a month. Even I can deposit a check in my bank account once a month. It's the path of how you get to that and getting to the right licensing deal that is vastly different than what people are explained in those scenarios. So from a legal perspective, Kevin, so someone goes through the process with an invention promotion company, they get a patent.
Okay. So plenty of my other colleagues, everyone in my firm, my classmates that are, registered patent attorneys, other ones that have walked kind of in and out of these doors. We don't charge for initial consultations. Get on the phone, call us, send us an email, find our contacts, sit down, let's have a chat about it. Let's figure it out. We have confidentiality with you over what you disclose with us, and we're here to help. Start there. It's not, I'm not going to.
You better make sure you better make sure that phone's working tomorrow morning, Kevin. That's all I have to say about
okay.
that.
I got there's plenty of people in this firm that are here to help, and there's plenty of other firms and boutique stuff. That's first step. If you don't feel good about it, go find, you can use the resources here, but there's a lot of us specialty firm boutique patent attorneys, and we're willing to field your calls. We're not going to charge you for it, but just ask the question. Let's help, because there's so many different things that could have happened. I could ramble on about it. We could do this, we could do that. get a hold of one of us. Explain your situation, and we're going to try to break down some options for you, and give you maybe some hard truths, but most importantly, some transparency and honesty. And that's probably a big breath of fresh air versus we're going to get this in the license. Like, I'm not going to tell you that. I'm not a business attorney, and I'm not going to here give you business advice. I'm here to examine what you have from patent or a patent application and give you some transparency about what you can do next.
But I want to leave, before we leave that question, Bailey, I want to encourage anybody who fits that description. Just because that was your initial experience does not mean you should give up. I will tell you, there are a lot of people, they didn't have any idea what they were doing. They started looking around, they see companies and they say all the right things and it sounds good and they don't know any difference, so they go down the path. Doesn't mean that they don't have a very valid project or idea or potential invention that can be very successful. So resiliency and perseverance are two of the most important traits in becoming a successful entrepreneur. And so just because you may have gotten knocked down or not or led astray in some way, shape, or form, don't let it derail your confidence and your belief in yourself, number one, but also in your ability to pursue it. So
Yeah, great. I think everybody needs words of encouragement like that. So thank you, Scott. And Kevin, I think you were segueing perfectly kind of into the next question as well. A lot of our viewers don't have an unlimited budget when it comes to these things. And so I did see quite a few questions around kind of what does the investment of a patent look like? Some people say, hey, is it going to cost $15,000 to $20,000 to patent my idea? And I
hold
know
on.
that
Can
is
I
a
start the
common.
answer? It depends.
Yeah, I was going to say.
There we go. He's learning. He's learning. The best way I can there's so many factors. What city are you in? Are you in a major metro area? Are you in a smaller firm? Are you in a bigger firm? Is it a boutique specialty place? What kind of invention do you have? Is it a simple utility invention, like it's a small apparatus? Is it a design? Utilities traditionally will cost more than designs, and we're talking at least double in that sense. So just get that in your head. Overall, we're going to go stick with the utility. You have a product, it does something, it has a function, it has a structure. We're not going to talk about the designs. Moderate complexity, it's got moving parts, it's going to do something. Well, you're looking at like a car payment, but not like a $30,000 car payment. Maybe somewhere more than 10, between 30. It depends on what you're doing, but you have to think of it as, I am going to invest in a vehicle. And there is a range of those used vehicles you could buy. You could buy a new vehicle. It's going to be more expensive. And then just generally, so people understand, the more complex it is and the categories it fits, the type of invention, it's necessarily going to be more expensive. If you have software, it is going to cost a lot of money, because that is an abstract thing. You have to explain what is going on in the computer. What are the algorithms telling the computer to do? And that has to be explained in words and in drawings, and it has to be broken down. That is a painstaking process. It takes a long time. So you have to factor that in there. But, if you made a model and it has a couple moving parts and there's a couple different variations, well, you're looking at a used car that's more reasonable. That's how I'm going to tell people, because depending on who you ask, what city you're in, it's going to be way across the board.
So Kevin is obviously, with a law firm. And so there may be a hesitancy to give numbers. I can speak from my experience. I've talked to a lot of people in numbers from different areas, and I can tell you utility patents, they really do vary, but I would say on average, utility patent, just really the filing aspect, 15 to 20,000 is not uncommon. You'll see some people that it's less. And keep in mind, the filing aspect is only the front end, right? Once you file, it's about 18 months or 24 months before, 90% or so get kicked
you're gonna have an office action, and then we have to argue it.
And then that's when the battle begins, the back and forth with the examiners. And that, attorneys don't, as nice as they are, right, Kevin, as nice as they are, they don't do that for free. So when we talk about the filing side of it, that's one expense. And then there's the other side. As far as design, like Kevin mentioned, usually about half of that. So I've seen 5 to 10,000 in that space. Provisional is a lot less expensive, because it's like grabbing a number in line at the deli, right? There's no approval.
Yeah,
so
you're getting
I got approved for provisional. Nope.
You're getting your foot in the door.
line.
Yeah.
Right.
It's that first to file. That's
Right.
what the provisional is. It's that foot in the door. And provisionals are not examined, so you can do it really informally, and you can save costs. Right? You can just have sketches instead of like formal patent drawings. You don't pay as many government fees, so the cost goes way down. In our practice, and I've worked with Scott here. We don't really do informal provisionals, and that's kind of just our strategy because we don't want to miss something, because that's the
Mhm.
first time you get to be patent pending. That's your first date you invented it, in the eyes of the law. So we do it in a, I wouldn't say it's like the absolute highest level, but we absolutely try to bring it to a very close level of formality, because we know this is the first date, and that's very important. So we don't really like to do it formally, but sometimes we don't have time.
Right.
Sometimes I had a case, guy put together stuff in like 48 hours. Not too bad. He's an engineer. It makes some sense. But there's not a lot I can do in that time. We barely get to discuss. He's going to go to a
Right.
trade show. So we have to take that and we put the cover sheet on it, and I read through it and put together a couple things that make sense. And then we put that in and file it. That's okay. He's patent pending.
Mhm.
But there's not an opportunity to really flesh out everything going
You're going to have
on.
to do a lot more on the back end of that than
Exactly. So it
right.
makes the non-provisional
Makes
more
that more
expensive
expensive.
because that has to be made up. And the way that, Scott, you and I go, we try to get a lot of that done so that later on, there's not as much work to do, and the
Because we're
focus.
patenting it, because we're generally patenting at the right time when we have more information that we
All
can
right, all right.
put
Not
in there.
everybody
All
has
right,
the
all right.
guru
No,
on their
no,
side,
I'm
okay?
joking. No, but the summary, Bailey, I think that it's expensive. It's not inexpensive,
Hmm.
but it is something that is valuable. And if you really care about your project and your idea, it's definitely a resource worth having. But that all goes back into, it's a resource, right? So you can spend all this money and then get this piece of paper and frame it and put it on the wall, and it's not going to drive you around like a car would for $20,000, and
No.
it may not produce any money for you. So that's why it's important that people understand, again, patenting is not the destination. It's a resource and a tool to help you get to the destination.
Yeah, it backs up what you're doing on the business side.
Right.
Yeah, great insights. So what do you guys say? One or two more questions? How you guys feeling?
Sure, go ahead, let's do it.
Yeah, we'll
Okay,
give it one more. Why not?
one more question. Alrighty.
Yeah.
Well, I know Scott kind of touched on this a little bit already, and we saw this submitted multiple times from some of our viewers. So I've got a patent, I've got a prototype, and I'm looking to license. Like what is the right path for these people?
Stay tuned and be back next time. So go ahead, Kevin. It's such a detailed. I mean, a lot of my time is spent talking about licensing, but your perspective, I'd love to hear it also.
Um, oh, this is so hard because it's like I have to be brutally honest and transparent. The odds of you have a prototype and you have a patent, if that's all you can give me, then I don't think that there's going to be many licensing opportunities. There has to be more. It can't just be, unless you've really, and trust me, there's exceptions to the rules. I've seen it here. I know of actual case examples. There's always exceptions. So I don't want anyone to be put down. But let's all be realistic. You have a patent and you have a prototype, and that's all you have. That is going to be a huge mountain to climb, because you're basically telling, oh, I'll come in here, go make this for me, figure out how to produce it, source the materials, run all the extra, finances and costs. That's not the best route. The better route is, I'm selling this. I've identified a bit of a market. I'm running free social media ads right now, and I'm promoting it, and I'm selling these. And you can identify that people want it and buy it. That's where a licensing opportunity might be beneficial, because you can actually demonstrate that this is being sold. Secondly, if you can sell a bunch of them, you've also sort of demonstrated that you can reproduce your product. You can sort of manufacture it. It might not be the most efficient, it might not be the most cost effective, but you can replicate it. And you can
Right.
replicate it so you can sell more. Those are some baseline things. You want to build that sort of, that foundation of the pyramid, so that people look and say, oh, wait a second, that is a market. People do want that. look at it, he's selling this and he hasn't even got outside of New York State. I'm in Buffalo. You haven't even gone downstate yet. There's more people there. Imagine if he goes to Pennsylvania. You're pulling people in. Scott, you say that all the time. You have to pull people in.
It's the
That is
pull.
the
It's
reality.
the pull, not the push. I mean, for our viewers, just imagine the scenario he started there with, right? Like you have a prototype and you have a patent, and you're going to these companies saying, "I need you to do the manufacturing. You do this. You do this. You do this." What type of deal do you think you're going to negotiate in that circumstance? It's not going to be a very strong one because the risk is very high for them. They haven't seen, as you described, the proof of concept. And we define that as sales, consumer reviews, and brand recognition. A lot of people, inventors. So there's inventors and there's entrepreneurs, right? And you can be an inventor and an entrepreneur, but you can also just be an inventor. An inventor just wants to ideate. They don't really want to, put the sweat, the work into actually developing it. And frankly, the best option for them is to find someone who does, because with just an invention and no real grit to do anything with it, most of them are going to collect dust. So there's that side of it. But with the risk in getting in, there's actually one of the invention promotion companies, I won't name them specifically, there's a court order disclosure statement on their website that 0.0001% of the people who have sent them money over the course of 5-8 years, something like that, have actually gotten just that amount back. And that's through licensing. So that's like 1,000 airplanes are taking off. And only one of them is going to land safely. I'm not getting on that airplane. And if this idea means something to you, you're watching this video, that it means something to you, then you should be taking the appropriate steps. So, and the last thing I'll say is this: when it comes to licensing, again, that's where everyone wants to get. Licensing deals are not all created equal. Okay. So in a scenario like Kevin gave, where you have a prototype and a patent, they're not going to give you a minimum annual distribution guarantee. They're going to want complete exclusivity, meaning that they have all the rights to your product. You can do nothing with it. And you don't have a leg to negotiate on, because you don't have sales, you don't have production. They know that you have nothing without them. A lot of times people are intimidated and saying, I'm just an idea person, or I don't want to, have this huge warehouse or run this huge company. We live in the 21st century where that's not required. There's the ability to outsource a lot of these relationships and find relationships that can help to oversee certain elements of the business. So when it comes to that proof of concept, it doesn't mean you need to build a $50 million company to open up the door for licensing. What it means is that you have to generate a strong enough proof of concept. Again, some sales, some consumer reviews, some brand recognition, to where instead of you knocking on the door of these billion-dollar companies like every other Tom, Dick, and Harry, they're coming to you because you're disrupting the space. And it makes more sense for them to license from you or buy your product or company outright than it makes for them to go and start trying to design something that maybe they design around your patent or compete with. You have to become dangerous. And when you become dangerous to them, that's when you become attractive. And that's when instead of an exclusive, no, you can handle wholesale, distribution, retail, but I want to maintain my e-commerce because my margins are the highest there. And okay, we can do a deal, but we're going to have a minimum annual distribution of $250,000 a year, regardless of how much you sell. I bet you they're a little more motivated to sell some product if they're paying that $250 a year, regardless, right? So again, we can get into licensing. I talk a lot about it. And so if anything, this is a great reason for you to come back and join us when we dig in a lot more to that topic, but this has been a lot of fun. So
yeah, it has. It has. I hope we got to give everybody a little insight there. And I'm just going to close. I mean, Scott, you were very positive on one thing. There are exceptions to the rule. All right, there is always exceptions to the rule. It's why I have to say it depends, because even when we think things are 100%, they're not. At the end of the day, do your homework, ask, make the connections, and first and foremost, if you aren't patent pending, delay an NDA. Don't start that timer.
We should hashtag that, delay an NDA.
No. All righty. Well, thank you guys. That was such a great conversation. I hate to even cut it off here, but like you said, we've planted the seed. This is only the beginning. It sounds like Kevin will be coming back in the future to join us for future sessions.
I think I got the invite, so.
Yeah, it sounds like you did get the invite. And
maybe down to Tampa. I know you're in Buffalo. It's a little cold, so maybe we could do it, with you here next time.
I can get down with that.
Awesome. But really, again, a big thank you to these gentlemen. You know, they both have families that they are in their office tonight and not home with their families so that they can be here with you guys. So a huge appreciation to these guys to be able to jump on here and go really deep into these topics that so many of our viewers are following want to know. So we appreciate you guys. And if you have any further questions to our viewers, or you're interested in getting in touch with Kevin, just know that you can email us at info@ideapathacademy.com. If you'll just drop that on the screen one more time so everybody can see it. But as a reminder to our viewers as well, we're going to be sending out a follow-up email, as well as in the YouTube description. If you're watching live from YouTube, we've got some links for you. You'll find our websites for more information. You'll also find the opportunity to book a call if you're looking for a more personalized experience. You want to get behind the phone. We're more than happy to talk to you guys as well. So just know you can get that via email or from the YouTube link. And of course, our free starter course. You know, tonight is a free opportunity to continue to knowledge share with you guys. And we want to also offer you the opportunity to view our starter course, where it goes into this topic deeper, even more topics deeper that are going to help you get your product to market launch successfully. So check out those links in the email and the YouTube live, and look out for our future session registration opportunity for our licensing webinar that will come in the
Bailey,
near
one
future.
last thing for our
Yeah.
viewers. That was great. One last thing, the info at IdeaPath Academy email. I think it's important, as we start to look at doing more and more of these and having, gracious experts like Kevin join us and adding real value to these conversations. It's important to me, and I know to our team, that we're delivering content that people want to hear about. So if there's another topic or other topics that you'd like to see us do series or talk about in the future, send an email to info at IdeaPath Academy. As Bailey mentioned, that Kevin and I, we're not here for ourselves at this point. But knowledge is power, and confidence is a demonstration of knowledge. So when you can when you know about what you're talking about, you can have these conversations and be more confident in doing so and going down that path. So please let us know if there's topics you want to hear about. But thank you, Bailey. Just want to add that in
Sure.
there.
Yeah. And I'll just round it out. I think, you said it well. Email us. There's so many avenues to get in touch with us. We want to hear from you guys. We will have a survey that goes out as well following this webinar. So give us your feedback on the webinar, and there's an opportunity to submit topics there if you don't want to email us. So whatever works. And as well, you'll get the recording. So recording will be live on YouTube. So if, you think this information could be valuable to somebody else that has an invention idea, we encourage you to share it and subscribe. But other than that, guys, I think that's all we have for this evening. I know we've gone well over an hour, and so I'm excited to dive deeper into the next topic here in the near future. So without further ado, I think we'll just go ahead and close it out here, and we'll say goodbye, everybody.
Good night.
Good night, everyone.